Great. Hello, and welcome to our My Fair webinar. My name is Shannon Garrett. I am the Chief Strategy Officer with the Michigan Women's Commission, and this is our My Fair webinar, FAIR, F-A-R-E. Just a quick note that you can turn on your closed captioning by clicking show subtitles at the bottom or turn on transcript. And again, my name is Shannon Garrett, the Chief Strategy Officer with the Michigan Women's Commission. I'm joined today by Madube Olatunji, who is a project coordinator for our Commission's My Fair webinar series. And today's presenter is Jennifer Fields, Wage and Hour Division Manager for the state of Michigan's Labor of Economic Opportunity. Just some quick background, the Michigan Women's Commission was created by statute in 1968 with 15 commissioners who are appointed by the governor to serve 3-year terms. The Women's Commission's duties include reviewing the status of women in Michigan, directing attention to critical problems that women face here in Michigan, and recognizing women's accomplishments and contributions to the state of Michigan. Because our recent surveys and conversations with Michigan women found an overwhelming emphasis on economic security issues, Governor Whitmer moved our commission from the Department of Civil Rights to the Michigan Department of Labor and Economic Opportunity in order to ensure more productive collaborations that will benefit women's prosperity around our state. We are, of course, still actively involved with the Michigan Civil Rights Department to ensure that gender equity is included in all of our conversations. You can learn more about the Michigan Women's Commission at Michigan.gov/MWC, and Madube will share that in the chat box. So last fall, the U.S. Department of Labor Women's Bureau, the U.S. Department, awarded us here in the Michigan Women's Commission a FAIR grant. FAIR, again, F-A-R-E, stands for Fostering Access, Rights, and Equity. And the purpose is to help women workers who earn low wages access all of their employment rights and their benefits. So thanks to that FAIR grant, the Women's Commission is proud to be putting on a monthly My Fair webinar series to share information with women all around our state. Each month, we focus on a different benefit, program, or workplace right, such as today's presentation about understanding Michigan's wage and hour laws, or next month's presentation in November on registered apprenticeships. We do have some our previous webinars are all recorded and are shared on our YouTube website or YouTube channel. And will soon be on our website at Michigan.gov/FAIR, F-A-R-E. So I'm pleased to now welcome you to our October webinar. Today's topic, again, is understanding Michigan's wage and hour laws. Before we get started, I just want to remind participants that you can turn on your closed captioning by hitting the transcript button or the show subtitles button below. And definitely use the chat box during this presentation to ask questions. And you will be able to revisit the presentation today once our recording and the slides are posted to our website and our YouTube channel. So now I'm excited to pass the mic over to Jennifer Fields, again, the Wage and Hour Division Manager at the State of Michigan Department of Labor and Economic Opportunity.
Great. Thank you very much, Shannon. Thank you for the invitation. I'm very, very pleased to be here and speak about a topic near and dear to me, Michigan wage and hour laws. Do have a PowerPoint that I would like to go through to share information with you. And again, my name is Jennifer Fields. I am the State of Michigan Wage and Hour Division Manager. There's also a federal wage and hour that enforces federal law. I am with the state. We enforce the state laws. So next slide, please, Shannon. Here's our little disclaimer. I'm not an attorney. I don't give legal advice. I'm going to share information with you that should be helpful, though. Next slide, please. We're going to talk briefly about these acts, but Michigan's Wage and Hour Division, right now we have 26 people that work for us. We enforce the Youth Employment Standards Act. We enforce Michigan payment of wages and fringe benefits. We enforce the Improved Workforce Opportunity Wage Act. That's Michigan's minimum wage and overtime law. Paid medical leave and the Human Trafficking Notification Act, which we're going to talk about briefly. We have our mission statement up there. Our goal is to always be fair and efficient in administering these laws. Next slide, please. Okay, we're going to start with Michigan Payment of Wages and Fringe Benefits. This is the act that we get the most claims about. Next slide, please. So under Michigan Payment of Wages and Fringe Benefits, this law applies to most employers and employees in Michigan. It does not apply to civil servants that work for the federal or the state government, but by and large, it covers just about everybody. Payment of wages requires that you get paid, whether it's hourly, salary, piece rate, commission, per widget, however the wage agreement is established. Wages have to be paid on a regular, reoccurring basis. You can be paid weekly, bi-weekly, monthly, or semi-monthly. Wages can be paid in U.S. currency. If anyone is being paid in cash, please make sure you get a signed receipt for that. It's not illegal to pay in cash, but certainly you need to make sure taxes and everything are paid. You can pay with a negotiable check or direct deposit or a payroll debit card. The law used to say you could not force people to have direct deposit, but that was changed. If an employee does not have a bank account and can't have direct deposit, the employer can offer a payroll debit card. Deductions from wages. This is something we get a lot of complaints about. With the exception of those deductions required by law or collective bargaining agreement, the employer needs to have the employee's full free written consent to make that deduction. The deduction needs to have the amount or method of calculation, the pay period it would be deducted from, and the employee's signature. The signature can be electronic. Signing a handbook at the beginning of employment saying you're responsible for everything, that is not sufficient written consent. Again, the written consent has to have the amount, the pay period will be deducted from, and the employee's signature. Okay. There is a provision in the payment of wages law that if you were overpaid based on a clerical, a typographical error, let's say you're supposed to get paid $10 an hour and you get $110 an hour, something like that, the employer can recoup that without your written consent in very certain circumstances. If this happens to you, we have a really good guide sheet on our website about this. The employer only has 6 months to find the error. They can notify the employee a pay period ahead of time, and they can only deduct 15% of the gross. That's 1.5. It should not take the employee below minimum wage. Next slide, please. Okay. Under the Payment of Wages and Fringe Benefits Act, 5 things are defined as a fringe benefit: vacation pay, sick pay, holiday pay, bonuses, and authorized expenses. Those are all pursuant to whatever the employer has in a written policy or a written contract. The employer is not required to have a written policy, but if they do have a policy, they need to follow it. And as an employee, you should read those policies. Does it say that if you leave with 2 weeks' notice, they'll pay you out any unused vacation time? Totally up to what the employer's written policy is. So I would suggest employees realize what the policies are and read them, make sure they understand them. Employers can't demand a fee or gift or tip to continue working or to get a job. Check stubs. Employees are required to receive retainable check stubs at the time of payment. The check stubs can be available online. The employee has to be able to have access to them. The only time that may be an issue is when somebody leaves employment. They may not have access anymore to the online system. In that case, I would suggest the employer print those out and mail them to the employee. Employees need check stubs, as we all know, for a variety of reasons, and they're entitled to have a retainable check stub. Act 390 also has discrimination protection. If you are discharged or demoted because you have filed a complaint under the Payment of Wages Act or exercised a right, the employer is not supposed to discriminate against you because you have filed a complaint. These can be difficult to prove. So just make sure that you're, maintaining documentation about what's going on. Okay, that's 390 in a nutshell. Can we go to the next slide, please? Okay. Michigan's minimum wage and overtime law. Okay, everybody knows there are two minimum wages. There's state minimum wage and there's federal minimum wage. Employers, as a general rule of thumb, should always follow the stricter standard. Right now, Michigan's minimum wage is higher than federal, so employers should be following Michigan's minimum wage. Michigan's minimum wage applies when an employer has 2 or more employees, age 16 or older. Michigan's minimum wage right now, today, is $9.87. Michigan's minimum wage should increase to $10.10 on January 1st, 2023, unless the state's unemployment rate for 2022 exceeds 8.5%. I don't want to say I'm super confident that it won't, but it's less than 8.5%. So this increase should take effect. Next slide, please. Okay. Michigan's minimum wage law also allows 16 and 17-year-olds to be paid a sub-minimum wage. They can be paid 85% of state minimum wage right now. That'd be $8.39. Tipped employees that receive gratuities, they may be paid 38% of the state minimum wage. So right now, that would be $3.37. They have to receive and report enough in tips to bring them up to minimum wage. If they don't, the employer has to make up the difference. This training wage for new hires, age 16 through 19, their first 90 days of employment, they may be paid $4.25 an hour. We don't get a lot of complaints that people have been paid the $4.25 an hour, but that is still a possibility. And my best advice is when you get a job or you're hiring people, let them know what the rate of pay is. The employer has a right to establish the rate of pay. They can, just like they can give you a raise, they can lower it as well. But employees also always need to know what rate of pay they're working for. Overtime, we're not going to talk about overtime a great deal, but overtime is typically anything physically worked over 40 and 1 work week. There are exemptions, people that don't have to be paid overtime, managers, professionals, supervisors, people employed in agriculture. If you have questions about overtime and who's exempt and who has to be paid overtime, you can always reach out to our office and we'll be happy to discuss your situation with you. Next slide, please. Okay, here we go with what's going on now in the news. Everybody remembers back in 2018 when there was a ballot initiative to increase Michigan's minimum wage. Instead of having it go on the ballot, the lawmakers voted to accept to pass as law the initiative, and then they went back and changed it. Recently, on July 19th, a judge ruled that lawmakers did not have the authority to adopt a piece of legislation and then amend it in the same session. So a judge ruled that it should have went back to the original version that should have been passed. There is a stay. It's not going to be enforced until at least February 19th, 2023. I can't tell you what's going to end up happening right now. I will ask people to keep an eye on our website. especially as that February date comes closer. The 1010, I'm 99% certain that's happening on January 1st. But we will have to wait and see what happens for February, because it would be a much bigger increase in minimum wage. So kind of put that in the back of your mind to keep an eye on our website as it gets closer towards February. Okay, next slide, please. Okay, thank you. Okay, let's talk about youth employment. And I know many people have jobs, and there's a lot of kids working right now. And I think it's important for you to have some idea what kids can and can't do, especially if you're working someplace. If your own family is working, it's good for you to know. So we're going to talk about youth employment briefly. Michigan's Wage and Hour has the Youth Employment Standards Act. The federal government has a Fair Labor Standards Act, and that applies to federal laws about minors. So employers, again, have to follow whatever standard is stricter, whether it's state or federal. Under Michigan laws, employers have to have a work permit on file before the minor begins work. And minors typically can start to work at 14. They need a work permit until they turn 18 or graduate from high school if they're less than 18. Minors can't be employed in occupations that could be hazardous or injurious to their health. Driving, delivering pizza or food, that is very dangerous work, and minors should not be doing that as a regular part of their job duties. There are hours restrictions for minors, 14 and 15-year-olds. State law says they can't work past 9. Federal law says they can't work past 7. Again, employers need to follow the stricter standard. Minors that are 16 and 17 can work up to 10:30, Sunday through Thursday. Friday and Saturday, they can work till 11:30. There are hours deviations for 16, 17, but parents have to sign and approve of those. Minors that are under 18 need a 30-minute break after 5 hours of work. And minors have to have adult supervision at all times. Minors under 18 should not be left alone to work. It's very hazardous for them to do that. And we ask that the employer be available close enough to help them if they need help. And there is a posting requirement. So there's a poster that the employer should display. You never have to buy these posters. They're available on websites for free. Next slide, please. Okay, so I just want you to keep in your mind that there are a lot of laws about youth employment, and we have really good information on our website. We just don't have enough time today to go into a lot of detail. So keep that in mind, though. Okay. Okay, paid medical leave. Here we go with this. Okay, this is also part of the adopted amendment of 2018. What I'm going to talk to you about right now is how paid medical leave is being enforced today. So, first of all, Michigan's paid medical leave applies when an employer has 50 or more employees that work anywhere in the United States, its territories, or its possessions. Okay, so you have an employer that has 50 employees. That's a covered employer. An employee is somebody that's designated, engaged in service to the employer, and they have to take out taxes. Okay, so that's a definition of employee. Next slide, please. Okay, so you have your covered employer. There are 12 categories of employees under this act that are not eligible for paid medical leave. All employees count towards a 50, but if the employee falls into one of the 12 categories, they are not eligible for paid medical leave. And some of the most common examples are people that are not employed primarily in the state of Michigan. If you work out of your home in Michigan and you never leave the state, Michigan's your primary work location. Individuals that can be paid the sub-minimum wage, the 16 through 19, they're not eligible. If you work for a temporary staffing agency, and you go to a host employer, you're not eligible. If it's a job that's scheduled to be 25 weeks or less in a calendar year, you're not eligible. If you worked for the employer last year and you did not average 25 hours a week last year, you're not eligible this year. And if you're a variable hour employee is defined in the Affordable Care Act as somebody that when they're hired, they're not expected to ever work over 30 hours in a week. The employer is required to do a look back period between 3 and 12 months to see if they went over that. And when they do the look back, if they've averaged over 30, then they become eligible. Next slide, please. Okay. So for paid medical leave, it's 1 hour for every 35 hours worked. Let's say you worked 40 hours in 1 week. You've earned 1 hour of paid medical leave. You have 5 hours towards the next 35. Okay, it kind of carries over. Does not have to exceed more than 40 hours in a benefit year. The benefit year is whatever 12-month period the employer decides. You can use, if you do the accrual method, the employer has to allow you to carry over 40 hours if you don't use them to the next year. Another option in the paid medical leave is to front load it. At the beginning of your employment, the employer says, here's your 40 hours of paid medical leave. If you do the front loading, you're not required to have that be carried over to the next year. Okay, next slide, please. You start to accrue leave right away if you're an eligible employee. The employer can have you wait until your 90th day to use it. It can be used in 1 hour increments unless the employer has established a different policy. Again, if they have a handbook, make sure you're reading it. And you have to follow the employer's customary practice for calling in. If they say you have to call within an hour of your shift or you have to talk to somebody, that's what you need to do. Follow their custom and regular practice. The one thing that the paid medical leave says is that it gives you 3 days to provide documentation. If you need a doctor's note under paid medical leave, the employer can require it. Next slide, please. These are reasons that people can take paid medical leave: for their own illness, for diagnoses, preventative care. We take that to be for dentist appointments, doctor's appointments, that type of thing. And when they wrote this law in 2018, it talks about if there's a pandemic. So if the if your place of childcare closes because of an illness, or a health official closes it, then you can use leave for that. And if you're exposed to communicable diseases and the health department says you have to quarantine, you can use your paid medical leave for that. Again, remember, this is only 40 hours in a year. Okay. You can also use it if there's a domestic violence or sexual assault situation, to receive care, to testify. In this circumstance, for the sexual assault and domestic violence, employers need to make sure all that information is kept strictly confidential. Okay, next slide, please. Okay, back to the adopt and amend. The original version of paid medical leave was called the Earned Sick Time Act. And it applies to just about everybody in Michigan. It applies if you have one employee. The only employees that are not covered under the way the Earned Sick Time Act is written now are federal employees. So everybody else would be a covered employee. This is the same thing as a minimum wage. The lawmakers voted to adopt the ballot initiative, and then they amended it. Again, the judge said that the same legislative body could not pass the legislation and then amend it in the same session. So we are watching this as well. There's a stay until February 19th, 2022. This earned sick leave will have a lot more coverage for people, more hours in a year. And this is something I really want everybody to keep an eye on as well. Because as soon as we have more information, we can post it, but it's a very fluid situation right now. And just kind of keep that in the back of your mind around February to see what's happening. And we will certainly post on our website, so keep an eye on that. Excuse me. Okay. Human Trafficking Notification Act. This is just good information, I think, for you to have. This law requires that certain business entities display a poster about human trafficking. Public rest areas, welcome centers. When you stop at a rest area now, a state welcome center, rest area, look for these posters. You'll see them. Bus and railway, public airports, adult entertainment facilities, and places that have been declared a nuisance based on acts of human trafficking or prostitution have to display this poster. We have the poster available on our website in all these different languages, as well as English and Spanish. So feel free, if your community group or your church group is interested in this and the posters, feel free to go on there and download them and use them as you wish. It just gives them a number to call if people suspect human trafficking. Okay. A big issue right now is employee misclassification. People are being told that they are independent contractors rather than employees. And that makes a huge difference. If you're an employee, the employer is telling you when and where to work. You only work for them, chances are you're an employee. If you have any issues with being misclassified, here's a couple places that you can report it to. If an employee believes they're owed unpaid wages, they can file a complaint with Michigan Wage and Hour. We'll investigate it. And one of the things we do is we send out a questionnaire to both parties to try to determine an employee-employer relationship. So these are good numbers for you to have. Next slide, please. Okay. We do accept complaints to investigate. For a payment of wage complaint, 12 months. Minimum wage and overtime, 3 years. For wage complaints, we do have to use your name. They are not anonymous. Paid medical leave claims have to be filed within 6 months. And people can file a complaint online at our website at the Michigan.gov/wage claim. Or if they need a form mailed to them, they can call us at our number. It's just the 855-464-9243. Here's a couple of questions that we get quite often. And I think we already touched on the employer changing your rate of pay. They can tell you today, this is what your rate of pay is. You need to know as an employee what rate of pay you are working for. They can't go back and say, oh, by the way, for the last 2 weeks, we've reduced your rate. But they can say from this point forward, this is what your rate is. And then you as an employee have a decision to make if you want to work for that new rate or if you choose to leave. Can an employer make overtime mandatory? We don't have any rules that say the employer, if you're over the age of 18, the employer can schedule you whatever hours they want you to work. There are some professions that have limitations, such as over-the-road truck drivers, and that's with Michigan Department of Transportation. If 40 hours, does that make me full-time? Michigan Wage and Hour Law, none of our laws define full or part-time employment. Again, employers can define that for themselves. So it's another reason why it's really important if they have any kind of handbook or policy manual, make sure you read it, make sure you understand it. Training time. If you are coming to on-the-job training that's directly related to your job, that is work time and you should be paid for that. The employer can tell you I pay training time at minimum wage. They can do that, but it is considered work time. Okay, we'll just look at record keeping real quick. And these are records employers are required to maintain for 3 years. It's also a really good idea as an employee that you keep track yourself of your hours worked so that you can say, wait a minute, this week I worked 40 hours and I only got paid for 30. What happened here? So employers are required to maintain all these time records for 3 years. Hours worked, starting, ending times. If you're a tipped employee, they have to have your signed tip statement. If they're making deductions, they need to keep your signed written authorization for that. 3 years. Next slide, please. Here's the posters. There are companies that will try to sell you these posters. You never have to buy these posters. You can download them for free from our internet, but be really careful. You don't have to buy them. Some of these poster companies charge people hundreds of dollars for these. You don't need to do that. So you can get them right for free from our website. Here's our contact information. Feel free to give us a call or an email. We are more than happy to answer questions. We have investigators on phone duty every day. We're more than happy to talk to folks and try to answer their questions. And I think that should be our last slide. Yeah. Are we doing okay on time?
Yep, we are. We've got 1 minute over, but I do have.
Sorry.
That's fine. No, it's all very valuable information. So thank you, Jennifer. We do have a couple of questions if you don't mind hanging on the line here. But in the meantime, for those who have to leave us, just a huge thank you to Jennifer for her presentation, as well as to Toy Bogan for our ASL interpretation services. We will be sharing these slides on our Michigan Women's Commission My Fair website, which again is Michigan.gov/FAIR, FARE. So thank you for joining us. But Jennifer, I did have one question that came up. It sounded like during the presentation that breaks are required for minors.
Yes.
But is there any requirement for breaks for adults in Michigan?
No. If you are over the age of 18, there is no wage and hour law that requires you get a break at all or lunch at all. That is a question I have probably answered 10,000 times in the last 27 years. If you are, again, in one of those professions that hours are regulated, like over-the-road truck driver, they have break requirements. But other than that, there's no law that requires. Most better employers understand that people need to have a rest break or a lunch break, but there's no law to require that. It is typically something that's in a union contract.
Okay. Thank you. And then another question that came up is for the paid medical leave, how is family defined, both under the current version and the version that may work with that?
Family is pretty broadly defined. It can be a parent, grandparent, children. If there's actual definition in the Act, and we have FAQs that answer that, I'm not going to say I remember every single one off the top of my head, but if you go to our website, Michigan.gov/wage hour, and you click on the paid medical leave, there is FAQ there that talks about who a family member is. And it's very similar to what the earned sick leave has in the version that's floating around right now. So,
okay,
yeah.
Great.
Yeah.
Well then, one last question, just are there any other common misconceptions about being in the workforce that you think we should know before we go, especially for women?
Yes, I will tell you that I have been a working mom for many years, and I think my biggest takeaway from being a wage and hour manager for years is people need to know what their rights are. They need to understand what the employer's policies are, what benefits the employer offers. No one's going to look after you and your money like you are. So you need to make sure you take care of yourself, read those policies, make decisions based on what's best for you. Keeping in mind that your manager may be somebody that has no experience, may not have any idea what they're doing. So take care of yourself. And if you ever have questions, reach out to the agencies. We have people that call in with questions, and they're information gathering. It doesn't mean they're filing a complaint. They just want to know what their rights are and what the law says. So that's what I would suggest is, read, educate yourself, take care of your money, because nobody loves it like you're going to love it. So
that's great advice to end on. Thank you, Jennifer.
Yes.
So thank you again. Really appreciate this information, Jennifer, and the work that you're doing to help enforce laws and protect all of us in our jobs. So thank you, Jennifer. Thank you again to Toy. Thank you to Modube for putting this together. Just to remind folks that our recording and Jennifer's presentation will soon be posted to Michigan.gov/fair, as well as to the Michigan Women's Commission YouTube channel. Our next My Fair webinar will focus on registered apprenticeships and will take place on Wednesday, November 9th from 10 to 10:30 a.m. Details on that will be coming soon to our website and to social media. So thank you everyone for joining us.
Yes,
we appreciate you.
Take care of yourselves, everybody. Bye.
Thank you.
Recording stopped.